Commonwealth versus Shuman.
Thank you. Mr. Harwood.
Good morning, Your Honors. I represent the defendant, Richard Shuman. This is an appeal of convictions for first-degree murder. He's convicted in connection with shooting deaths of two business associates, Jack Badler and Howard LeBreau, which occurred on August 5th, 1997. The conviction was in October of 1999, case tried before Judge Botsford. The issue raised in this appeal is that a defense was not presented that Mr. Shuman's conduct resulted from Zoloft. And in particular...
Let me interrupt you. Zoloft was a drug that was in a, I can't recall the name of the broad category of drugs, but whatever that broad category was, weren't they on notice at the time of his trial that that broad category of drugs caused aggression and so forth?
The broad category, Judge, is SSRI.
Yes, okay, SSRI.
And we contend that what is new is that after the trial, there was a clinical study.
Oh, I know. There was a clinical study, and the FDA came out with things.
Right.
But I'm just talking about the SSRI category of drugs, of which Zoloft was one. Wasn't there?
There was evidence that SSRIs could cause akathisia and resultant violence. What there wasn't at the time of the trial was a clinical study specifically linking Zoloft to
Zoloft
akathisia.
in particular.
Right. And prior to the trial, drug manufacturers would defend civil litigations by saying you can't extrapolate from Prozac, for example, that Zoloft would similarly be a risk of violence. But what we say in terms of what's new is that the clinical study by Dr. David Healy of the University of Wales came after the trial, and it specifically linked Zoloft.
But is the expansion of research on the subject, is that the equivalent of newly discovered evidence? Because if it were, there's always going to be new, I hope, everybody hopes that science is going to always get better and expand, more research. Does that mean that every time there's an expansion of the research and the literature on the subject, there's going to be a new trial?
I think it's different when this is the first study as to the drug the defendant was put on 8 days before the murder. And in addition to that, after the trial, Pfizer, the manufacturer, for the first time admitted through its experts in 2 depositions that there was a risk factor.
Mr. Howard, help me deal with this. I've got Judge Botsford's memorandum here on page 3-4, which is at page 27 of the record appendix. She says a cursory glance at the footnote references in your expert's, Dr. Glenn Mullen's affidavit, demonstrate that the link between SSRI, including Zoloft, and agitation that leads to ideation or violence has been the subject of study in medical articles since the early 1990s. And then she cites, endless footnotes.
There's no question that there was an emerging awareness in general prior to the trial that SSRIs in general might be linked to violence. There was no study.
It might be. They were linked.
Well, it hasn't been a change in the medical thinking until recently because of the suppression of information by drug manufacturers.
Well, we have nothing we've got unsupported claims by, very broad claims by your expert of the suppression, which Judge Botsford seems to discount.
Well, clearly...
I don't know what suppression means.
Well, clearly it wasn't until the deposition by Pfizer that there was a public acknowledgement by the company that this was a risk factor, and clearly there was no...
Yes, but there were endless studies. The manufacturer may not have disclosed. I mean, that may be grounds for complaints about the manufacturer, but, I mean, if your expert is bringing to the judge's attention all of these articles from the 1990s that show that there is a connection between taking SSRIs and increased violence.
It may well be, as I've argued, that it was ineffective of trial counsel not to raise a Zoloft defense. I raise the point in the brief, though, that there was no clinical study linking Zoloft specifically, that there was no public admission by Pfizer prior to the trial that there was a risk, and there certainly was no FDA warning, which came out in 2004, that there had been a sea change in the thinking, and that now the manufacturer had to list akathisia and violence as a potential side effect of the drug.
May I ask you this? Let's say, just hypothetically, that there are, say, 100 different drugs that fall under the SSRI category. And today, one of the 100 different drugs came out with a clinical study that said this causes aggression, and then the FDA today came out with something. Now, you've conceded that going back to the 1990s at least, there was some general discussion about it.
Correct.
Would you take the same position you're taking on Zoloft, that until the specific drug is the subject of a clinical study, until there is some kind of public notice from the drug company, until the FDA issues a specific warning on that particular drug, that it's not evidence that is available to the defense?
I think what I'm generally suggesting is that there were reasons that perhaps...
Yeah, but I want to answer to my hypothetical.
If what you're asking, Judge, is could this opinion by Dr. Glenn Mullen, for example, have been advanced in the absence of the study, I guess my response would be maybe if he had had the Bridgewater records, which showed a marked improvement once Mr. Shuman was off Zoloft. I can categorically state that Dr. Glenn Mullen in this case, until he saw the full Bridgewater record, was not in a position to offer an opinion. But unfortunately, the Bridgewater record, which had been requested by counsel, was not provided. So neither Mr. Reddington nor Dr. Burston had available the medical record which showed steady improvement once the client was taken off of Zoloft and, I would add, treated with Ativan, which is now a known treatment for side effects of akathisia. And I understand what the Court is saying in terms of the argument that it's not newly discovered. I'm suggesting that there are reasons because of the emergence of evidence in the literature, this study in particular, and as well the fact that the Bridgewater record was not requested but not obtained by counsel, that it may fall in the category of newly discovered evidence.
Yeah, so maybe I'm going to try to ask the question differently. Are you saying that there has to be a study specific to the particular drug, or in order to make that argument, that until a specific study on the particular...
I am saying that.
Okay.
Whether the Court adopts that reasoning, I am saying that, and I'm saying that undoubtedly there would be a defense that this SSRI literature is not specific to this drug.
I take it from Judge Botsford's memorandum that she's, in essence, finding, almost as a factual finding, although she's quoting from Lefebvre, that evidence is not newly discovered because recent studies may lend more credibility to expert testimony that was or could have been presented at trial. I mean, it's I think the import of Justice Island's questions is you're really opening up lots of, quote, new evidence, unquote. And particularly here where, as Judge Botsford then goes on to, and she was obviously the trial judge, was that was the defendant's expert was reasonably close. In other words, it was not as if this jury didn't know. I mean, I can understand. Let me back up. I can understand, Mr. Harwood, if it's accepted medical practice for a physician to prescribe SSRI, and nobody knew that this led to violence, and then there's a series of studies. But I mean, the whole thrust of his defense was he was put on SSRI, and he had an expert testifying that this, you know, there are endless studies that say that this leads to violence.
Well, I think that's the next important question, because whether it's newly discovered or whether it's ineffective, I have to show that it would have made a difference.
Sure.
And the difference, I would suggest, is crystal clear here. Dr. Burston testified that Mr. Shuman's conduct basically was caused by a depression which reached psychotic dimensions and had a delusional component, whereby Mr. Shuman was in fear that his business associates might physically harm him and or his family. He only, as an aside, mentioned that Zoloft might be a complicating factor when combined with Elavil. He never used the word akathisia. He never provided any testimony concerning SSRIs causing akathisia, much less Zoloft causing akathisia. And the whole parlance of his testimony was psychosis bordering on delusion. The problem with that defense was that all of the other defense witnesses said, as Dr. Gardo said, I didn't see that he was a danger or a risk of harm. The night of the killing, Dr. Kelson Daniel said he's not delusional in my view, and he's not psychotic. So here you had the defense expert who saw Shuman long after the fact saying he's psychotic and delusional, while all of the other defense experts were saying he's not delusional or psychotic, including 8 days before the killing and immediately after it. Now, the reason that defense didn't work, Dr. Annunziata immediately seized upon that and said it's contradictory, and the prosecutor in closing understandably hammered home, this doesn't make sense. There is no psychosis or delusion according to these three defense experts. The difference here, and what the truth is, what was missed is that Gardos, 8 days before the killing, saw a man who was not a risk to himself or others. What changed in those 8 days? What changed was that Mr. Shuman was put on Zoloft. And so that was the explanation.
Just in terms of background, now, at some point, he had made suicidal gestures. He had a gun in his lap, and he said to his wife, when did that occur in relationship to the murders?
There were instances of suicidal ideation in July, I would say beginning in April, leading up to August. But the important thing is there was no evidence that he was acutely suicidal. When Dr. Gardo saw him 8 days before the killing, it was specifically asked, should he be hospitalized? Is he a risk to himself or others? Gardos didn't see it. That's because he wasn't on Zoloft at that time. Now, what changed was 8 days of Zoloft, which the FDA now acknowledges at the beginning of therapy may be a risk for violence. And Dr. Healy's study found that about 1 in 10 people may have this risk, not 1 in a million, as Gardos generally thought. And as Dr. Annunziata said, it's no different than any other drug like Elavil. But the critical difference would have been, as Dr. Glenn Mullen points out, that Zoloft was consistent with the three defense experts. Zoloft, as the cause, was consistent because Gardos wouldn't have seen a risk of harm, and Kelso and Daniel wouldn't have necessarily seen evidence of psychosis or delusion. Zoloft calls akathisia, which is a panic and or rage reaction, and not psychosis or delusion. Dr. Glenn Mullen's opinion is based upon a panicky type rage reaction, and he notes that when Shuman was at the police station in custody, he was fidgeting all about, he was sweating, and the police thought, we better get emergency personnel in here, he's diabetic, maybe he's having a problem, and they check out the blood sugar, and lo and behold, there is no problem with the blood sugar.
Let me ask you this, and I'm not asking you to explain why, but it would make a much stronger case, I believe. You've essentially got two defense experts who are equally well qualified, and they, serve, in fact, at the same hospital, same medical school. If the defense expert had come in and said, this is what was known to me, this is what I testified to, now we have this study, which really does put the Healy study, that, now we have an FDA warning, now we have, Pfizer's acknowledgement of these particular side effects. Had that been available to me or to any other expert at the time, I would not have talked in general terms about depression leading to, a psychotic level or whatever it is. I would have focused specifically on the changed behavior between what the treating psychiatrist or psychologist saw when he went, to see whether or not he should be committed, and what happened in the intervening days. That, it seems to me, would be a different situation, but Judge Bostford said that she really can't accept Dr. Glenn Mullen's surmise that, this was not available to Dr. Burstian.
Well, trial counsel commendably put in an affidavit admitting...
that's trial counsel. That's trial counsel.
And trial counsel is the person ultimately responsible for the defense, and trial counsel says there was no strategic reason not to present.
You go to a physician or an expert. You don't have to tell the expert what the expert comes up with a theory, a perfectly legitimate theory based on the then science. You're coming in and saying it's new because the Healy study plus the FDA plus Pfizer made it new. And the easiest way to substantiate that claim, which is by far the safest way to go, is to go to Dr. Burstian.
What you have in the record is an affidavit from the attorney responsible for the case saying he was unaware of the link that's been presented here. He didn't make a strategic reason to forgo a Zoloft defense. And the record is crystal clear that the defendant was never consulted concerning raising it. And the record is also clear that the full Bridgewater record was never obtained by trial counsel or Dr. Burstian. So,
was Dr. Burstian aware that he was on Zoloft?
Yes.
Was he aware that that he was taken off Zoloft?
I would presume yes, but all he had was a 12-page summary from Bridgewater Hospital.
Was Dr. Burstian aware of the fact that the defendant had consulted, I don't know whether it was a psychiatrist or a psychologist, 8 days before or 9 days before?
Yes.
That psychologist testified, did he not?
Yes, he's the one who said 8 days
before
so he saw no risk of harm and no risk of danger to others.
So a physician, an expert looking at this would say, here's a psychiatrist saying no risk of harm, something clearly went wrong, there seems to be an intervening fact, Zoloft. If Burstian had said, as Mr. Reddington said, he was not aware of the link between Zoloft and akathisia, is that how you pronounce it?
Mm-hmm.
Akathisia? That's different.
Whatever his motivation or his investigation, what we know is the lawyer responsible says there was no strategic decision made to forgo the defense. Judge Botsford didn't hold an evidentiary hearing on the point Your Honor is mentioning, even though it was requested. But more critically, it's clear on the ineffective claim that perhaps the full record should have been obtained because it was obtained by Dr. Annunziata. And Dr. Annunziata selectively quoted portions of the full record to support his contention, where Dr. Burston and Mr. Reddington were in the dark on that. It was simply never obtained. And the record shows a steady course of improvement once Mr. Shuman is taken off the Zoloft. It also shows contemporaneous objections to being put on the Zoloft-type medication that Dr. Burston was unaware of, and that Bridgewater State Hospital officials kept urging because they, back then, didn't know that there was such a link between violence and Zoloft.
May I ask you a question? Your time is up, I see, but I'm curious about what you say about 33E review.
33E is critical here because, setting aside technical objections on is it newly discovered and, how complete is the record in terms of why the defense expert did or didn't say something that he should have said. The bottom line is the credible explanation for this conduct that would have been consistent with what every medical expert was observing was that Mr. Shuman was prescribed Zoloft. He took it for 8 days. He had no criminal record, and then he shot 2 men to death. He was adjudged not a risk of harm to himself or others by Dr. Gardos. His behavior at the time was robotic. It was rambling. It was incoherent. It was consistent with akathisia. And he steadily improved once he was off the Zoloft and treated with Ativan, which is a medication for akathisia side effects. And therefore, in the interests of justice, the jury, at the very least, should have heard a coherent and credible defense which would have explained the conduct and been consistent with all of the medical indicia linking this conduct.
Thank you, Mr.
Thank you.
Howard. Ms. Kukavka?
Good morning, Your Honors. Varsha Kukavka for the Commonwealth. With me is Assistant District Attorney Susan Corcoran. The defendant wants to take all the evidence now and sift it through a different filter, narrowing it down from the full and strong defense that he had at trial on the lack of criminal responsibility and pull it down to saying, no, it was just Zoloft, but not only that, it was also only this akathisia that caused me to do the murders. There is no standard met here for newly discovered evidence, and there is no standard met that there was a serious error by trial counsel.
Pretty compelling case for why we should consider this on a 33E basis, don't you think?
I do not, Your Honor. The evidence was, and the jury found, complete premeditation, methodical execution of 2 people. The Zoloft issue has nothing, it was there. It was at trial. Dr. Burston said there were tremendous, terrible, toxic side effects because of Zoloft mixed with these other medications and the defendant's mental state.
Don't you think if the defendant had the warning from the FDA, that would have affected the jury?
Your Honor, what's interesting is that the FDA, the defense makes a big thing now of the FDA warnings. I have provided in the supplemental appendix Cloud v. Pfizer. It's an excellent case. First of all, it collects all of the research pre-97, which was the date in that case. Here, trial was in 99. But there are cases on Zoloft listed in the research there. As well, I found out yesterday that it lists the 1999 warnings that were on Zoloft up until the recent change in warnings. They're virtually the same. They don't say akathisia, but they say aggressive reaction which is basically what he's claiming. They say
I
paranoid.
take it that what the jury had, I don't wish to misinterrupt you, and you can provide that to Mr. Harwood and to us, but I take it that essentially the Commonwealth's position goes something like this. There was quite strong, compelling, I'm not choosing the adjective, evidence that this defendant had hostility towards his two particular victims.
Yes.
Specific, not just because they'd had a fight that night or something, and that this had been growing over some time, and there was evidence that he actually had, so the Commonwealth would say, planned or taken some steps which would indicate in retrospect that these two victims were at risk from this defendant long before he took Zoloft. The jury had that evidence. The jury also had evidence that from the defendant's point of view, he was depressed, suicidal, and was placed on drugs which had the impact of exacerbating violent tendencies, correct?
Yes.
And that, in essence, if you put Dr. Glenn Mullen on the stand, the jury would have the same evidence again.
Yes.
Namely, you wouldn't have a trial where you would exclude all of the evidence that tends to support premeditation. The planning, the collapse of this business, the activities that the defendant thought the former chief financial officer was engaged in, and so on and so forth, correct?
Exactly. In that sense, Dr. Glenn Mullen would not add anything. In fact, he might reduce the effect of the defense that was presented.
Because?
Well, by making it a kind of, he didn't do it, it was just the medicine, rather than all of the factors that were going on with him, all of the additional depression and, what Dr. Burston called up to mind before the jury that was leading up to this.
What is the strongest evidence of premeditation?
Well, he selected his most powerful weapon, a 9mm. He had a number of weapons.
When did he make that selection?
Well, that's the gun that he brought to the office.
So he's on Zoloft, right? So we've got premeditation.
Well, he was prescribed Zoloft. There are no tests that show any kind of level of Zoloft in his system, but he was prescribed Zoloft 8 days before, a normal dosage.
Did he fill a prescription?
Pardon me?
Was a prescription filled? Was he given Zoloft?
Yes, he had a bottle that was taken after the shootings. But as far as, I'm sorry, but your question is...
I was trying to think of the premeditation, the evidence of premeditation. And
Well,
I just want to separate what was premeditation during the Zoloft period and premeditation prior to the Zoloft period.
Well, premeditation, leading up to the very time of the killings, he was supposed to sign a release, and he was telling his former partner, I don't want to sign this, I'm not going to sign this, releasing Jack Badler and Howard Lebreau from, releasing them from liability if the business went down. He was, telling everyone that he told Jack Badler before he shot him, you've ruined our lives, you've ruined our business. He had a direct motive, and this is what I'm doing to you because this is what you've done to me. You can't get any more deliberate than that. And then...
All of this, of course, while he was on this medication, or at least during the period for which this medication was prescribed.
Well, to a witness, Your Honor, and each one was asked, was there anything unusual about the defendant's behavior? Was there anything unusual about the way he was walking? The akathisia defense, there are two components to it. One is subjective. You can't really measure other than by self-reporting. The other is observable activity. To a witness, they said there was nothing unusual.
I take it that that's the observable activity to which Mr. Harwood made reference during his argument of when he was at the police station, that he was...
He claims that when he was restrained, he was under such, force of this akathisia. And that at Bridgewater, the best evidence is that on intake, the person that checked off for akathisia was 0. That's in the medical records. They also checked off normal body movement. On intake, the fact that he might have been pacing in his cell, he told people at the Bridgewater Hospital he didn't like being cooped up. To take those descriptions and put them into, this defendant was suffering from akathisia to such a degree is ridiculous.
Now, what I'm suggesting is that if the Zoloft was causing that, then the people who observed him before the killings would have similarly observed.
Exactly, and no one saw anything.
What kinds of symptoms would
It's
an observer have seen in the defendant, which would have indicated Zoloft was in his system shortly before the crime was
It's an
committed?
inability to sit still. It's a pacing. It's an agitation. It's you can't keep your legs still. I looked it up in an old medical dictionary where they originally said it was a neurosis, inability to stay seated. But, it's been expanded through the years with, with the neuroleptics and people. It's mostly in the legs. The person will just keep rocking their legs or shaking their legs, or they just have to pace. No one saw anything like this. He was walking normally. He came in, he sat down, he had the gun in his hand, then he put it away, then he took it out, and then he committed the shootings, and then he, talked to people, don't worry, I'm not going to hurt you, drove at a normal rate of speed to the next place, went in and shot Howard Lebrow. The shootings were, so deliberate into the face, the chest, the neck. This is not the example that the defense claims in the Healy study. First of all, the Healy study, 20 healthy volunteers who happened to work for Dr. Healy at the hospital.
The Chief Justice asked you about evidence of premeditation. Wouldn't some of the evidence of premeditation be in the fact that he selected the two victims with whom he had grudges or against whom he had grudges, and he went from one to the next? And the very fact that he went from one to the second is evidence of premeditation.
Absolutely. It's completely
But does
methodical.
Zoloft negate premeditation? I mean, pharmacologically?
No, not in any way. To call it an involuntary intoxication, there's no evidence of intoxication here. And as I was starting to say with the Healy study, where he says that this one volunteer became so, I don't know if he uses the word intoxicated, Healy himself, but that she became under the sway of the akathisia, that she was going out and she was going to throw herself in front of a bus.
But isn't the defendant just saying that he's not denying that he had these feelings towards these people? He's just saying that the consumption of this drugs put him in a condition where he was not able to control that.
He was not able to control the very deliberate choice of going to that person and shooting him, and then going to the other person and shooting him.
Yeah.
That is from the other extreme of someone wanting to take their life and throwing themselves under a bus. And all of the reference to akathisia and violence, it really should be more suicide ideation. There's not so much about violence with akathisia. It's more the person just feels so uncomfortable, they just don't know what to do with themselves. They just want to die. This,
Was there any, I'm sorry, was there anything in the record of suicidal ideation either after the homicides?
After, at Bridgewater, he was more or less on a watch, and I think they all said that they'd asked him, did he have any thoughts of suicide, and I think, he kept saying there was no plan, there was nothing like that. And his mother reported that he reported that after the shootings he really wanted to shoot himself, but he didn't. Instead, he let his mother get a hold of the guns, or I think he brought them in a box.
Did he have any suicidal ideations that he expressed to the psychiatrist a week before?
The week before, he did not tell his psychiatrist that he had attempted suicide in any manner, nor did his wife report to the psychiatrist, Gardos, that there had been these attempts. This only came out at trial later. As far as ineffective assistance of counsel, Your Honors, the defendant had the best attorney you could have in the state. he put on a, he made no error in focusing the way he did on the lack of criminal responsibility. In fact, his affidavit doesn't say he would do it otherwise, knowing now what he knows. He brought out...
I did find, I read Mr. Weddington's affidavit, and he does say that he asked for the Bridgewater records and didn't receive them.
Yes.
And he received a summary. It doesn't, that struck me as a little unusual. Usually when you're asking for something, I mean, there was no refusal to give the records, was there?
I've been told by the trial attorney, Assistant District Attorney Corcoran, that she doesn't believe it was the case that he didn't get them. I can't represent one way or the other. In the record appendix, he's providing a letter asking for the records and then just the competency report. I don't know. I do know that Dr. Annunziata did have it at his disposal because he testified as to it. So,
well, Mr. Weddington said that in an affidavit that he didn't receive them, and there's no reason for us to challenge that. I mean, it's a sworn affidavit, so for whatever reasons.
But at trial, having heard Dr. Annunziata refer to it, he certainly, if he had...
That's what I'm saying. That's what struck me, that he didn't follow up, and particularly as this started coming out at trial. In other words, there's nothing in the record to suggest that anybody refused to give him. They may not have given it to him, but there's no court order saying...
No, there is no dispute. There was no dispute in the record as far as I didn't get these. If there are any other questions?
Thank you,
The
Ms.
Commonwealth asks that this Court affirm the convictions. Thank you, Your Honor.